When a judge speaks of political pressure, justice rarely remains standing. History, across continents and across eras, gives us a consistent pattern. When the courts begin to tremble, the walls of government begin to shake. In Nigeria, that warning has resurfaced, not through rumor, not through speculation, but through a document. 6 pages. Type. Measured. And devastating. A sitting judge, presiding over one of the most sensitive cases in modern Nigerian history, has stated formally that he is under pressure. The document by Justice Omotosho has become far more than a legal complaint. It is a mirror held up to the Nigerian state, reflecting shadows many knew existed but few dared to name. This is not the story of a trial. It is the story of a system under stress, a judiciary caught between duty and power, and a nation confronting questions it can no longer avoid. Today we examine the leak that shook Abuja, and what it reveals about the state of justice in Nigeria. The arrival of the document was unceremonious. No press conference. No dramatic announcement. Just a formal letter addressed to the Chief Judge of the Federal High Court. Inside it were the words no judiciary wants to see. I am writing to formally report sustained political pressure regarding the ongoing trial. The phrasing was clinical, the kind of language judges use when every syllable may one day be studied in courtrooms or archived in legal memory. But beneath that tone lay something unmistakable, urgency. And beneath the urgency something deeper, fear. Within hours of being filed, the complaint began to circulate quietly through legal networks. By afternoon, journalists had fragments. By evening, social media burned with speculation, screenshots, and analysis. A judge had spoken. A system had been exposed. And the country held its breath. To understand the magnitude of this moment, one must understand the trial at its center, the prosecution of Nnamdi Kanu. Kanu is not merely a defendant. He is a symbol, a rallying point, a figure whose influence extends far beyond courtrooms into the political, cultural, and emotional spaces of Nigeria. His rendition from Kenya in 2021 was condemned by multiple international bodies as violating international legal norms. His detention has stirred nationwide debate. His trial has never been simply legal. It has always been political. For the government, he represents a challenge to national cohesion. For his supporters, he represents resistance against a system they believe marginalizes their region. Inside that tension sits the judiciary, the one institution expected to rise above politics. But Justice Omotosho's complaint suggests that the courtroom had already become a battlefield long before the public realized it. Political pressure rarely arrives dramatically. It enters quietly, subtly, through conversations, through suggestion, through implication. According to judicial observers and past documented cases, pressure often follows a distinct pattern. First, a phone call. Not to the judge but to someone around him. A colleague. A mentor. A senior figure. The message is soft. This case is important. Be mindful. Be careful. Then come the meetings, described as consultations, not directives. Polite, cordial, but unmistakably purposeful. Suggestions begin to surface. Certain testimonies should carry more weight. Certain motions should be seen as unnecessary. Certain timelines would be helpful. And then the reminders grow firmer. This judgment is being watched closely. There are expectations. There are national interests at stake. It is rarely explicit, but it is always clear. For a judge committed to independence, such pressure becomes a quiet burden. One that grows with each ruling, each hearing, each procedural decision. And eventually, a point is reached where silence becomes impossible. For Justice Omotosho, that moment came the day he put his concerns into writing. When the complaint leaked, the response was immediate and explosive. Legal analysts dissected every line. Activists raised alarms. Opposition figures demanded accountability. Government supporters dismissed it as overblown. But one fact remained. A judge in active service claimed he was under political pressure. Such an admission is rare. In some countries, it has happened only moments before institutions collapse. In others, it has signaled the beginning of reforms. For Nigeria, it was unclear what direction the moment would take. What was clear was that the complaint had pierced a veil, revealing something many believed but few could prove. The story did not stay within Nigeria's borders. International bodies responded quickly. Amnesty International expressed concern and called for a transparent investigation. The United Nations Human Rights Council added Nigeria to its watch list for judicial independence issues. The European Union issued diplomatic statements reminding Nigeria of its obligations under international law. Foreign governments took note. Some quietly contacted Nigerian officials seeking clarification. Judicial independence is not simply a domestic matter, it is a global standard. And when that standard is threatened, the implications reach far beyond national borders. Investment climates shift. Diplomatic relationships adjust. Confidence in governance structures begins to erode. Nigeria found itself facing scrutiny more intense than at any point in recent years. Judicial pressure is not new in Africa, nor is it new in Nigeria. In apartheid-era South Africa, judges later admitted they faced intense government interference. Those admissions, once public, accelerated changes that the government could no longer control. Nigeria's own history reveals familiar patterns. During the 1990s military era, courts were regularly influenced to silence critics. Judges who resisted were isolated. Those who complied were elevated. The echoes of that past now mix with the present. What makes 2025 different is transparency. Information moves instantly. Leaks travel globally. And public pressure is more difficult to contain. Where silence once protected institutions, openness now challenges them. Inside the judiciary, the complaint created tension and courage. Some judges privately acknowledged similar pressures. Some began documenting their own experiences. Some considered stepping forward. For a judiciary to admit vulnerability is rare. For multiple judges to share that sentiment, even quietly, is extraordinary. At the institutional level, the chief judge established a committee to review the allegations. But critics argued the process lacked transparency and urgency. Legal bodies demanded more. The Nigerian Bar Association held emergency discussions. Senior lawyers threatened to withdraw participation in federal courts unless real action was taken. A single complaint had evolved into a national conversation about judicial independence. The government, facing mounting pressure, attempted to contain the narrative. Official statements focused on procedure. Spokespersons urged the public to avoid sensational interpretations. But the global and domestic reactions continued. Civil society groups organized peaceful protests. Editorials and newspapers questioned the health of Nigeria's institutions. International media began exploring parallels with cases around the world where judicial pressure signaled deeper political issues. As the noise grew, the credibility of the ongoing trial came into question. The defense argued that continuation under such circumstances was impossible. Human rights organizations agreed. Even neutral observers noted that the legitimacy of the trial process had been compromised. The question was no longer whether pressure existed. It was how deeply the system had been affected. After months of tension, an internal committee released a report. Its findings were careful, cautious, and for many disappointing. The report acknowledged irregular communications, but stopped short of confirming undue influence. Reactions were immediate. Some legal practitioners saw it as a missed opportunity. Others saw it as an attempt to minimize the gravity of the situation. And then something unexpected occurred. A group of federal judges issued a brief joint statement acknowledging that they, too, had experienced pressure in various forms. They did not name cases. They did not accuse individuals. But their message was unmistakable. Judicial independence was under strain. It was an unprecedented moment, one that shifted the national conversation. With public trust shaken, international observers watching, and the judiciary itself speaking, the government faced a dilemma. According to reports, senior officials began exploring a way to de-escalate the growing crisis. Eventually, the Attorney General announced a new legal position. Because of procedural issues related to Nnamdi Kanu's initial rendition, the court lacked jurisdiction. The case would not continue. For some, this was a necessary legal correction. For others, it was a strategic retreat. What was clear was that the trial had become unsustainable. Pressure on the judiciary had become a national issue. And the government sought a path forward that would stabilize the situation. When Nnamdi Kanu was released, reactions varied. Supporters celebrated what they saw as a vindication. Critics questioned the timing and motives. Observers noted that the legal basis for the decision was consistent with long-standing objections raised by rights groups. But beyond celebration or criticism, the moment raised a broader question. What happens to public confidence when a major trial collapses under concerns about judicial pressure? Some argued that the release restored a measure of legitimacy. Others believed it exposed systemic issues that required urgent reform. The truth, as always, lies somewhere in between. In the weeks after the case ended, attention shifted to the future of Nigeria's judiciary. Discussions emerged about reforming reporting procedures for judges. Legal scholars proposed new protections against political interference. Civil society groups advocated for independent monitoring of sensitive trials. Justice Omotosho remained silent publicly after filing his complaint. But according to those close to him, he once shared a simple reflection. "I became a judge to serve justice. And when justice and power come into conflict, the law must guide us." His 6-page complaint has now become part of Nigeria's legal history, a moment where the system confronted itself. And the questions it raised will continue to shape national conversations for years. Stay informed, stay safe. This is Truthline Africa.